Good morning, everyone. I want to welcome you to Myths and Musts. We're going to learn about probate and estate planning today. And with me, I've got J.M. Preston. And he is an attorney and California State Bar specialist in estate planning. He has drafted over 8,000 estate plans and has also reviewed over 5,000 estate plans prepared by other attorneys. So he not only knows how to do his system well, but he's also reviewed enough other systems to have an unmatched perspectives in how families can protect their assets.
Yeah, thanks, Chris. Chris and I have known each other for, I don't know how many years.
Ever.
A long time, since we were kids. So it's good to be here today, and I'm excited. You guys are going to learn a lot. So get your pen and paper out or your iPad, however you take notes, because there's going to be a lot of good information we're going to cover today. We're going to go through it a little bit quick and cover a lot, but I think you'll find it very helpful.
Yeah. And then I'm Chris Jensen. I'm a realtor here in San Diego. I've been a realtor for around 15 years. Started in property management and then construction and then real estate. So kind of have a really well-diverse background. I can help you buy a house, then fix it, then rent it, then sell it. Kind of all the things that you might need to do, having to do with properties. And my full focus, now that I've got great teams running the property management and construction, is real estate sales. So we're going to go over how to protect those assets today. And if you have any questions, feel free to reach out to either one of us after this webinar if we don't get your questions answered today.
Yeah, and that's a good point. We'll just mention, I think Chris said this, but the questions that you type into the chat are private. Nobody else can see them. So if you're anxious because someone's going to see your stupid question that you think is stupid, that's okay. No one will know but us. And honestly, there's no stupid questions. I know everyone says that. But the reality is estate planning is complicated, and it's hard to understand these things. And so if you have a question, just type it in. If we don't get to it, it's not because we didn't like your question. We just probably had too many questions to get to. So. And
I see a question asking if you'll get the video of the presentation after. You'll be sending.
It'll be automatically emailed out. Yeah. So if you registered for today, which obviously you did if you're on, you'll get a recording after you can watch again. Okay.
Good. All right. So we're gonna jump in here and ask some questions, and then I'm going to do a little bit of the talking. JM's going to do most of the talking. But
I'll try and keep it to a minute.
I'll try to keep him interesting. How about that? So let's start a little bit with probate. So everyone hears probate. Everyone, you heard your friend's parents died and now they're stuck in probate. What are they stuck in? What's probate?
Yeah, probate in its simplest form is just court. That's really what it is. It's going to court, getting before a probate judge, and dealing with assets after somebody dies. So the reason why it gets such a bad reputation is because, well, for one, nobody likes court, obviously. But it takes a long time, and it's very expensive. And so when people hear the word probate, they think, oh my gosh, this is going to take a really long time, and there's going to be lots of fees, and it's going to be just a nightmare to deal with. But that's what probate is.
And what triggers probate? When does that start?
This is an interesting question because I'll hear often people will say to me, when are you attorneys going to get rid of probate? You created this thing and you got to get rid of it. It's a problem. Here's the funny thing about probate. It is not the problem. It is actually the solution. It's not a good solution. Like, nobody wants to go through probate, but it's solving a problem that candidly you created. Maybe not intentionally, but here's the problem. The problem is somebody died and we need their signature. That's the problem. So for example, if you own a home and you have your name on the deed and you die, there is no way to get that name or that deed out of your name without your signature. And obviously if you died, we can't get it. And so people say, well, how do we fix this? How do we get the property transferred to the family? Probate. We go to court and it's a solution. It's kind of like saying, well, let's get rid of hospitals. I don't like going to the hospital. It's not fun. Well, yeah, nobody does, but it's the solution to a problem, right?
So the problem is you might not have prepared all the way, and now this is the messy solution you have to go through.
This is California's solution. By the way, I should mention this because I saw a couple people pop in here that said they were saying hi from other states, which is totally fine. You're welcome to join us. everything we share today is going to be based on California law. I am only licensed in California. There may be some similarities in other states, which is fine. That's why you can listen in. But just keep in mind, this is strictly for California law.
Yeah.
Those are my little disclaimer.
Yeah. And I've got Kate over here off to the side. Kate, if you can, she can't see these questions, can she?
No, but we'll keep track of it.
Yeah. So we'll keep track of your questions.
Yeah.
I see a lot of questions coming through. We're going to kind of get through kind of probate and estates, and then we'll loop back around and we'll scroll up. So you might see us fingering the computer over here trying to get up to your questions. We'll try to catch as many of them as we can as we get through. What are some of the biggest myths about probate?
You know, there's a lot of things that I hear where, for example, I have a will. I have a last will and testament, and therefore I've taken care of everything. I won't go to probate. Here's the interesting thing. Wills are actually designed to go through probate. That's their sole purpose. When you die, your will goes to court. Even if you don't have to go through an official probate, a will gets filed with the court every time somebody dies. So when you say, well, I've done a will, therefore I'm good, you're still going to end up in probate if you don't have a trust, because the will is basically giving the judge instructions on what you want. Now, here's the ironic thing. If you had, let's say, 3 children, and your plan was to leave your assets to your 3 children, let's say you're not married, or you are married and both you and your spouse have died, and your plan is to leave it to your 3 children.
Okay.
If you put a will together and it says, I want it to go to my 3 children, it'll go to court, go through probate, and it'll go to the 3 children. If you didn't do a will, you will die intestate. Intestate means you didn't have a will. But then the court says our default in California is it goes to your children. So a lot of times, and this doesn't apply to everyone because some people have some crazy distributions, right? When they die, it's pretty weird. But if your plan is to leave it to your children equally, the will doesn't do a whole lot, with one exception, and that's nominating guardians. You nominate guardians if you have minor children, but if your children are all adults and you want them to get it, whether you have a will or not, it's going to be the same result.
Gotcha.
Kind of interesting.
So having a will does not save you from probate. That's one of the myths.
No, it'll actually send you directly to probate.
Okay. What about cost? If you haven't set up a trust and you go through probate, what are some of the potential costs there that are going to happen to your estate?
So the cost varies, but if you want to write this down, and this again is California, it's about 5% of the asset value. Now here's the part that people don't realize. It's the gross value, not the net.
Ooh.
So if you buy $1 million property today and you die tomorrow and your mortgage is $800,000, you've got $200,000 in equity. The probate court says we're going to base the probate fee on $1 million, which is about 5%.
Ouch.
Yeah, it doesn't make any sense. I don't know why they did it that way, but I've had many probates where the family says there's not a lot of equity here. And it's like, well, yeah, but you can't unlock that equity unless you go to probate court. And they go, but they're charging me 5% on the value, and it's not really the value. It's the problem with probate. They don't differentiate between net and gross. They just say, what's the gross value?
A blessing of living in California.
Yeah, exactly.
Okay. All right. Great. And then let's I got 2 more questions on probate, and then we'll kind of keep on moving down. Yeah. Who is in charge during probate? Is it the court or is it the family or?
A little of both.
Okay.
So when you go to court, the court appoints somebody. Usually, if you know it's your children, they'd be appointed as your executor. One of them would be. If you've nominated an executor in your will, they would be in charge. But everything they do is subject to the supervision of the court. So technically, the court's in charge.
Okay.
Right? Like if you said, well, we want to sell the property before the probate's over because we don't want to keep the house. The court has to approve that.
Oh, okay.
And if you say, well, we're ready to move to the next stage in probate, the probate court has to approve it. And a lot of times what takes so long in probate is waiting for the judge to give you permission.
Right.
So you submit a petition to the court and they say, okay, our next available hearing date is in 4 months. And you go, 4 months? What am I going to do for 4 months? You're going to wait until your hearing date. And so the court really drives everything, which is the frustrating part of a will and probate, is you're just kind of at their mercy. And on a good probate where everything goes according to plan, 12 months.
Yeah.
You're in court for 12 months. I mean, obviously not every day, but you're waiting and you're submitting and you're hoping that they approve it. And then a year later they go, okay, you're done. And you go, oh, That was a long time. So
that brought up another little question for me. If you're wanting to sell your property during probate, you've got to jump through some other hoops, not just get approval to sell it, right? Appraisal, you got to sell it for a certain amount. And what are those rules?
Yeah, and that's why everything has to be approved, because the judge wants to make sure that you're not doing something fishy, you know? Like, well, I'm the executor, I'm one of the kids, I'm going to sell the property to me for half its value. And all the other kids are saying, wait a minute, why do you get a good deal? So, yeah, everything has to be approved. And it takes time. So oftentimes people sell homes when someone dies, especially nowadays with the new property tax rules, which we'll get to in a minute if we have time. But oftentimes now the property is sold. And when you have it set up correctly, which we'll get to later, you can list it, honestly, the day somebody dies if you wanted to. You won't be able to necessarily close just yet, but you don't have to wait.
Yeah.
Like, it's quick. So if you say, let's get rid of the house, we don't want to pay the taxes, we don't want to pay the insurance, we don't want to deal with all the upkeep, we just want to get rid of it, and maybe the market's good right now, let's just get rid of it, you can just do it. It's pretty immediate.
That's awesome.
Yeah.
Okay. And then you already answered how long it takes. Usually at least a year, right?
Best case scenario, yeah.
Okay. So then tell us, how can we avoid this year of walking around not doing much?
Yeah. So most people, especially if you've watched any of these types of videos, you've heard of a living trust. A living trust is not a legal thing. It's a marketing thing that came up probably 40 years ago. But here's why it's important. When you die and you own a home, we need your signature. The trust doesn't die just because you died, which is why they call it a living trust. It lives on after your passing. And the reason why that's important is if you put your asset, we'll just use your home as an example. This is probably most people's biggest asset is their home. So if you take your home and you put it in a trust, you don't technically own it as an individual, you own it as a trustee. Now, some people hear that and they get nervous and they go, well, do I not own my home? Can I not sell it? Can I not refinance? Now, you can do everything you could have done before. It doesn't change that. Still yours. You can sell it. You can refinance. You do everything you want. But because you're serving as trustee, when you die, we don't need your signature. Because in your trust, it'll say, when I die, my successor trustee is so-and-so, like your son or daughter, usually, right? So they go into the county recorder and say, my dad died, here's a death certificate, here's an affidavit, it proves that I'm the trustee, and just like that, you're in charge. What takes a year to get your name on title can be done in basically a day. You don't have to walk down to the county recorder, obviously. It can be done electronically through the mail, but the point is it's immediate. It's that quick. And that's why they call it a living trust, because it will live on despite your passing.
Okay. I've got a couple questions here that have popped up that I would like to pop in on.
Okay.
Going back to probate, who covers the cost? Where does the money come from to pay for everything?
The probate, there's two parts to probate. There's the court costs, which are around a couple thousand. That starts up front. But the actual big fee, the 5%, that's paid at the very end. And it'll come out of the probate estate.
Okay.
So usually it's because something was sold. But this can create problems where you might say, well, we want to keep the house because we don't want to sell it, right? It's our family home. But where are we going to come up with $20,000, $30,000? Right. The executor's got to pay it. And so sometimes they get a loan, sometimes they pool their money. It's a big problem, right? Like, it's hard to come up with $30,000 just to inherit a home.
Yeah.
And
then the next one, so let's say they have property in California, but they also have property out of California. What does that do to probate, and does the living trust help with that as well?
This is a really good question, because we're dealing with this right now. We have a probate for a person who died in California. They were a resident of California, but they owned a home in Washington State. And they didn't have a trust. They didn't have anything. So now we have to open two probates. There's an attorney in Washington who's opening a probate for the property, because that's where the property is. So it's subject to Washington's jurisdiction. And we have to open a probate in California because the decedent was a resident of California. They call it a dual probate. So you think it's bad to pay one probate fee. Imagine doing it twice.
And does a trust eliminate that problem?
It does. In fact, a lot of times I'll hear people say, well, if I have property in California and I own property in another state, I need to have 2 trusts, one in each state. That's not true. You can have just one trust in California. It's always based on where you live, your residency. And then you can go into the other state and have a deed prepared that transfers that property into your California trust. Perfectly fine.
Okay. One more along these lines. Got some questions coming through about creditors. So when your parents die and they've got some debt that needs to be paid, how does that work? And what if there's not enough estate to pay all the creditors? Is kind of the follow-up question to that.
Yeah, the rule is pretty simple. When you die, your estate, which is everything you own, is responsible for your legitimate debts. So credit cards get paid off. Mortgages get paid off. Obviously, if you sell it, they have to. That'll go through escrow. But let's say you die and you've got more debt than you have assets. That debt will never pass on to the beneficiaries.
Oh, that's good.
Yeah. So if they say, hey, we don't want to deal with this, we're just walking away, perfectly fine. They don't transfer debt. And a lot of times the creditors are the ones that get the short end of the stick. But that's the way it works.
Okay. And I've got about, just so you guys know, I've got about a question popping up every 2 seconds. So I am trying to kind of get the broad general strokes of the questions that are coming through, but we're definitely not going to get to all the questions today, but we'll do our best. So let's talk a little bit more about a trust. So what is the difference between, what are the different types of trusts? How about that? What are the different types of trusts and what's kind of the direction you're seeing most people go with these days?
Yeah, this is one of those tricky questions because if you Google this, you'll get so much bad information out there. One of the most common questions that I get is, what's the difference between revocable and irrevocable, and which one do I need? 99% of the time, you need revocable, and here's why. Revocable means you can make changes to it. So you set it up today, you name your son as your trustee, and then in a year, there's a falling out, and you go, I don't trust my son, I need to name my daughter. Revocable means you go in and just amend it, and you're done. It's very simple, it's very easy. Irrevocable means you have lost that ability. You do not have the ability to amend it, change it, it is set in stone. Why would somebody do that? Well, again, most people don't need that type of trust, but usually it's done for gifting purposes. Like, my estate is too large and I don't want to die and pay taxes, so I'm going to give things away, but instead of just giving it to my family, I'm going to put it in this irrevocable trust so they have protection. And if it's irrevocable, I no longer own it. I don't have control. It's out of my taxable estate. So when I die, the IRS doesn't tax that trust. Okay. Nowadays, with the limits are so high, the estate tax limit right now, this is 2025, if you're watching this later, is $13.99 million. Okay. So you can imagine most people don't exceed the limit. And if you're married, you double that. So it's unusual to see people go above the estate tax limit these days, which is why our revocable trust is typically, for most people, a sufficient type of trust.
Okay. Yeah. Good. Let's see here. Actually, let me pop in here and see about a couple of this. And yeah, for those, sorry, we answered this at the beginning, but yes, there will be a copy of this session.
I've seen a lot of those questions
that gets mailed out again. So you'll get that. And then, a lot of stuff. I do have, let's talk about planning before death. So we've got, what are the other documents that we prepare other than a trust that kind of helps get the estate ready? So like, for example, power of attorney, what does that do, and how is that important in the overall bucket of preparation?
Yeah, this is probably the most misunderstood document in estate planning because if you watch TV or you hear news, the power of attorney sounds like the document that solves every problem, right? We all hear that. It's like, oh, just do that power of attorney. Good. We're done. Problem solved. In reality, power of attorney is not used very often. And it's not designed to be used very often for 2 reasons. Number one, the power of attorney dies with you. So it's not going to be like a living trust that continues on after your death. Its sole purpose is to deal with incapacity issues. The trust, however, can do most of the stuff as it relates to incapacity if you design it properly. And that's a better way to do it because banks, financial institutions, title companies, they all are familiar with trusts and they like them. They hate powers of attorney. They hate them because they're subject to fraud. They've been burned in the past. And so whenever you try and use a power of attorney, you're usually going to run into problems. You know what I mean? Like the bank's going to say, we sent this to our legal department. They don't like it. And you go, well, why not? And they go, I don't know. I'm not the legal department. I'm just the messenger. And you go, well, what do we do? Right? So that's why powers of attorney are tricky. When do we have to use them? When we don't have a choice? Usually 2 reasons. Number one, the trust doesn't cover it, which would be something like an IRA, a 401k, a credit card, something that's outside the trust that you can't put in the trust.
Why don't we actually, because I've seen about 20 questions pop through on that.
I've seen that too.
What are some things that don't go in the trust? Are 401ks, IRAs, those don't go in the trust?
Usually, so those are the big ones because even if you want to put it in your trust, they won't let you.
Okay.
So if you went to your IRA custodian and you said, I have this IRA, make my trust the owner, they would say, we can't. Because the minute we put it in your trust, it will cease to be an IRA, and that's basically an early withdrawal.
Oh, okay.
So you get hit with a penalty and tax, and so they just won't do it. They won't because they don't want you to pay all those taxes. Those are the big ones. Annuities oftentimes don't go in the trust, but it kind of depends on the type of annuity, and there's so many. One that comes up a lot is vehicles. People always think they need to put their vehicles in the trust. The answer is you don't have to do that. There's no benefit to doing it unless you like going to the DMV and you want to sit in line and put it in your trust. You can. There's no problem with it. But vehicles don't count towards probate. So when you die, there's an easy form with the DMV that your family can sign and it transfers the title and you're done.
Okay.
So those are the big ones.
I'll bring up another one that in the real estate world I've seen is, people will have their house in a trust, then they'll refinance, and the financial institution wants them to put those loan documents in their name.
Mm-hmm.
And so now all of a sudden their house is recorded outside of the trust again. And they think, well, my trust had a pour-over will as a part of it.
Mm-hmm.
That should cover me. Is that right? Is that pour-over will going to cover everything that they forgot?
Yeah, that's a good example, Chris, because that's the number one cause of probate with our clients. Not because we did anything wrong. We set up the trust, we put their home in the trust, everything's done, and then years go by and they do a refinance. And a lot of lenders nowadays will say, just take it out of the trust, we can do the paperwork, and then we'll put it back in. They don't always put it back in, as you've probably seen. And so nobody knows, they don't tell us, and they just did their refinance, they think everything's great, and then one day they die, and we go to the county, and we pull the deed, and we go, wait, 10 years ago, your dad put this property in his name, why? And usually the son or daughter will go, oh, that was the time he refinanced.
Oops.
So that is a probate. There's no way around it, or it's at least going to be court. There's some other ways to get around full-blown probate if you qualify, which is hard, but you're still going to have to go to court. The reason we have the will, and I'll tell you what it's called. Chris used the term, I don't know if you guys caught this, but he said a pour-over will. When you have a trust, you don't create a typical will. You create something called a pour-over will. And a pour-over will says very simply, when I die, everything I have goes into my trust. Hence the term pour over. It's like I have a pitcher of water, I'm going to pour it over into my trust.
If I forgot something, it goes in here.
Yeah, it's a safety net.
Yeah.
And so when people get the will, when someone dies, often I'll have clients' children call me when their parents die, and they go, can I get a copy of the will? And I go, yeah. But you're going to be disappointed because it just says it all goes to the trust. There's nothing in there. And they go, oh, well, I want to see the trust, which they do get a copy of. So the pour over will is very simple. It says, if I forgot to put something in my trust, pour it back in. But here's the problem. That's probate. So now this home that's in your name because you refinanced now has to go to court. The judge says, let me see the will. And we say, Your Honor, here's the will. And the judge says, oh, it goes to the trust. So then the executor at the end of probate takes that home and pours it back into the trust. So the good news is, at least it goes to the people you wanted to as it's designated in your trust. The bad news is we got to wait a year and spend a lot of money.
Okay. Still got to go to court. So...
Yeah.
If you refinance...
Yeah, I was going to say, that's good. Go ahead. Sorry.
Put it in your calendar about 6 times to go and go and put that back in the trust, or you might be causing some problems down the road.
I actually saw one of my clients did a refinance, and the day they were signing all the loan docs, there was 2 deeds in the loan docs.
Okay.
One deed took it out, one deed put it right back in.
Oh, smart.
And I was like, that's smart, but it's weird because you're almost not doing anything. It's like we took it out and we put it back in like the same second. Do you know what I mean?
Jumping through hoops.
Jumping through hoops.
Yeah.
Usually what they'll do is they'll say, take it out of the trust first and let us do the process, and then when we're done, you can put it back in.
Right.
I've never seen it where they do it simultaneously. But like you said, it's someone going, check the box, we did it. You know?
Yep.
So.
What about checking savings accounts, those kind of things? Are those in the trust? Sorry, I'm jumping around a little bit.
No, it's a good question. Here's the funny thing. You could look this up online, and you could probably talk to 100 attorneys, and you would get very different answers.
Okay.
And that's why it's a good question, because there's not really a consensus out there on what's best. Well, let me tell you why there's a problem with this. Most attorneys that I've talked to say don't put your checking and savings account in the trust because they don't reach the probate limit, which is true for a lot of people, right? Money goes in, money goes out. You don't keep a lot in your checking. It's just there to pay bills. The probate limit in California right now is just over $200,000, which means if you have a bank account and you die and it's not above $200,000, it will go through something called the small estate affidavit process, which is not court. So attorneys say, well, if you don't have much in your checking account, don't worry about it. Don't put it in the trust. When you die, your kids can just do this small estate affidavit and they'll put it back in. Here's what they don't tell you. And the bank will tell you that too. I've heard the bank say this all the time. Here's the problem. You set it up this way. One day you get dementia. And your son goes into the bank and says, my dad's got dementia. He doesn't know Tuesday from Thursday. He's giving money away. He's not paying his bills. I am his successor trustee. The bank says, well, that's interesting. This isn't a trust account. And the son goes, yeah, but I'm the trustee. And they go, wait, you don't understand. We don't care who you are. This is not a trust account. You have no authority. And then the bank freezes the account because they just found out their client got dementia, right?
Right.
So now the son doesn't have access, dad doesn't have access, and then they go, well, don't worry about it. When he dies, just bring the death certificate in and we'll give you control. And he's thinking, well, what if my dad lives 5 more years? What am I going to do with his account?
How am I supposed to pay the bills?
Yeah. So even though you may have checking accounts where money goes in, money goes out, put it in your trust. There's no harm in doing it other than you have to go to your bank and tell them to do it, but that's easy. And it's just so much better. That way, if it does exceed the amount, just maybe you start saving money and it gets larger than the probate amount, we're good. And if you become incapacitated, your successor trustee has access.
Okay, good.
Yeah.
One more. I'm going to go back just a little bit to the pour over will. I'm getting some more questions on there. Is there a limit to what a pour over will can do? For example, if I've got $1 million house and that I've got the mortgage paid off, and I refinanced and forgot to put it back in the trust, is my pour over will gonna cover that whole amount, or am I gonna? Is it?
You mean without going to court?
Without going to court?
No.
What is there any limits of what I don't have to go to court for in a pour over will?
Yeah, it's a dollar amount. It's a little over 200,000, but it's cumulative. So if you said, well, I had 3 accounts and each one is less than 200, but if I add them together, they go above the limit, then you go to probate. It's cumulative. But for real estate, I don't remember the number because this is just not practical in California. I think the number used to be like $60,000 was the real estate limit. Mm-hmm. And you're like, well, what property in California is less? I don't know.
It's very small.
Yeah, so I don't even remember the number. There is a real estate number. Basically, if you own real estate, you're going to go to probate if you don't have it in a trust. That's just the bottom line.
Yeah. All right. Let's go. Have you seen any questions here that you want to jump in on, or I'll just grab another one here? And we're almost to where, actually, let's just scroll through these questions.
You want to take a look? Yeah, these are good questions.
We've gone a half hour and done a good amount on the questions we had prepared. So let's see what questions.
We'll just kind of start grabbing them. Can someone want to know about adding the home as an additional insured for your trust? The short answer is yes, do that.
Add the trust.
Add the trust as an additional insured. Here's what happens, and we saw this in the LA fires earlier this year. Your home is owned by your trust, but you're the one with the insurance. Two things can go wrong. Number one, this isn't as common, but I did see it a few times. At least my clients told me about it. The insurance company says, all right, your home is in your trust, but you're the insured, so we got a problem. We can't pay out. And so sometimes it's a paperwork nightmare. Sometimes it's a disaster. Like I have to go to court and fight my insurance company because my trust owned the home, but I'm the insured, right?
Oof.
So you add the trust as an additional insured. And then the other reason why we do this, the reason why it's helpful is we have had cases where somebody will pass away and their home, something happened. Like maybe it's the same event, like somebody died in a fire and their home burned down. Well, now the insurance company is sending you the check, but you died. So your kids get this check and they can't deposit it because it could be for a lot of money and you're the one that needs to deposit it. That's a probate. If you do the trust as additional insured, they can just issue a check to the trustee and then they put it in the trust account.
Okay. Good question. Great
Yeah,
question.
Very good question. There's so many.
Yeah, just so you guys know, I think we probably have about 500 questions in here.
Oh, this one I saw a lot. When it comes to IRAs and 401ks, people want to know the advice I always hear attorneys say. This is funny. They tell you what not to do on your IRA. They don't tell you what you should do. So here's the advice that's pretty generally well respected. They'll say, don't name your living trust as the beneficiary of your IRA, which is true. For the most part, that's a bad idea. Here's why. When you name, let's just say you have children and you want your children to be the beneficiaries. When you name them, they get some really good tax benefits. Not as good as it used to be before the Secure Act, like in 2020 when they passed that, but still relatively good.
Okay.
So there's some tax benefits for naming a living, breathing person. If you name your trust, it is not a living, breathing person. It does not get those same tax benefits. Mm-hmm. And so even though it goes to your children because they're the beneficiaries of your trust, it could strip away some very good tax benefits. So there's usually two general recommendations we have. Everyone's case is different, so be careful. This is not advice. This is just generally what we see. If you have adult children and you are confident that they can manage their money, just name them directly. They will get it. They're living, breathing people, so they get the tax benefit, and you're comfortable with them getting the money and doing good things with it.
Okay.
The exception to that would be if you have one of three situations. Number one, minor children. You don't want to name a minor child because if you die and they're a minor, they have to go to court. Well, not them, but somebody. Somebody goes to court on their behalf to hold the money for them because they're too young. And then the worst part is at 18, the court says, okay, you're an adult. Here's your money. And they go, sweet. I'm 18 and I just inherited $100,000. We're going to Vegas with my buddies, right? Like, and it's all taxable too. So they spend the money and then they get a tax bill the next year and they go, what do you mean I have to pay taxes? Nobody told me that.
No.
So minor children is one. Number two is a spendthrift, which in plain English means someone you don't trust with money. Mm-hmm. So they may be an adult, but you just go, if I give them the money, they're just going to blow it. So I'd like to have some restrictions on them. And then the third one is like a special needs beneficiary who maybe is getting government benefits or they're just not capable of managing money due to their disability. So in those three instances, what you can do is name something called a retirement trust.
Okay.
A retirement trust is a special trust that's designed to work with IRAs. It's not a living, breathing person, but in the eyes of the IRS, it is. They basically say, if you can meet all these requirements, we're going to pretend like your retirement trust, which is just a piece of paper, is a living, breathing person. So now someone's in charge of the money for your minor, spendthrift, special needs, and we get all the same tax benefits we would have gotten.
Okay.
Really cool. So
cool tool.
We just answered like 50 questions because
yeah, there's a lot of
there was a lot on the IRA and the trust and how that works.
And JM, if someone's in California but they're not in San Diego, can you still help them?
Sure.
So
yeah, we cover the whole state of California. This is rare for an attorney to do it, but we started in 1981. I know I don't look that old. My dad started the firm back then. So if you're wondering why I don't look like I'm 70, that's because I'm not. But my dad started in 1981, and we've always covered the entire state. We use mobile notary, FedEx, email. We have clients all over the place. And they always say, why do people hire you? You're not in the Bay Area. You're not in Orange County. You're not in LA. You're in San Diego. The reason they hire us is we offer things that other attorneys don't. And we touched on a few of them today. I don't have time to get into all of them. But yeah, we cover the whole state.
Okay.
Not a problem.
Good.
Did you see other questions? I'm scrolling through so fast.
So many questions. Here, let me. I know I had a question from actually someone emailed me a question. So let's say someone wants to maximize their net on a home at the end. I know what I wanted to talk about. Decedents trusts. So
Decedents. That's okay.
If you sound it out, it sounds like I said it.
I know. I clients always called that too, and I always say it's a decedent's trust. It's fine. You're good.
Number one, if you've got a decedent's trust, and you want to maximize what your kids are getting out of it, tell us a little bit more about that. I've got a question that says, does my decedent's trust still get the one-time $250K exclusion? What latitude is there in dividing assets between the survivor's trust and the decedent's trust? Just give us a little bit about the decedent's trusts and kind of how to maximize those, or if they should be.
So there's kind of two groups that you're going to fall into. But I'm going to talk about the first one because the second one I can't do much with. So the first group is somebody who, and this term decedent's trust, survivor's trust that we hear a lot, the common term people use is AB trust.
Okay.
Have you heard of an AB trust?
Yeah.
A lot of people haven't, but if you have, that's what an AB trust is. The A is the survivors, the B is the decedents. If you're alive and your spouse is alive and you have an AB trust, that's a good thing. You still have time to change it, and I'll tell you why you want to change it here in a minute. But the second group is you had an AB trust, your spouse died, and then your trust split into an A and a B. That's really hard to fix because the B trust, the decedent's trust, is irrevocable.
Ooh.
And irrevocable trusts are hard to deal with, and there's some exceptions, but they're complicated. We won't get into it today. So if you have a decedent's trust because your spouse died and you have problems with it, there's very limited things we can do. There may be some, but everyone in the family has to get along, and we have to look at taxes. It's complicated. But let me address the people that are in the first group, which is your spouse is still alive, and you might have an AB trust. By the way, if your trust was created over 10 years ago, you probably have an AB trust. Not all the time, but yeah. Because it was just very common back in the day. The idea with an AB trust was it would avoid estate taxes when you died. I won't get into the details on how, it doesn't really matter, but the point was it was avoiding an estate tax.
Okay.
The estate tax limit nowadays is almost $14 million. If you go back 20 years, it was like $1 million.
Okay.
So you can see how things have changed. Back in the day when it was $1 million, people said, well, if I own a home and I have some money in the bank, I might be at $1 million already. And if you went above it, it was a 40% tax.
Right.
So it got you. So attorneys came up with this thing called an AB trust, and they said, well, we'll avoid the tax by doing this AB division. Well, the problem is the B trust, the decedent's trust, was very good at avoiding estate taxes, but not so good at avoiding capital gains. It would basically pass a bunch of capital gains onto your family when the survivor died.
Ouch.
And so nowadays what we're seeing is families are coming to us and saying, well, my mom died 20 years ago. Dad divided the trust. Now dad died and we want to sell the house. Part of the house is in a decedent's trust. All of those gains over the past 20 years are going to pass right on to the children. Now people are thinking, and you're probably thinking this too, wait, there's a step up in basis, right? Don't you get a step up in basis when somebody dies? You do, but not on a decedent's trust. It goes back to the basis when mom died, when the first spouse died.
Oh, no.
So, yeah, so if someone is, had like 20 years between when the spouses died, can you imagine the gains on 20 years in California?
San Diego.
You know that. I mean, this is your bread and butter.
Yeah, that's a lot of money.
That's a disaster. So people always say, why did they do AB trust if there was this capital gain? Well, the estate tax was 40 to 50% over the years. Mm-hmm. Capital gains may have been 15 to 20%. So if you had to pick, you would always pick the bigger tax, obviously. If you fast forward to today, most people don't have 14 million. So now they may be triggering a tax they didn't have, and they're trying to avoid one they don't have.
Gotcha.
Totally backwards.
Okay.
I should add one thing real quick, because you guys are probably thinking, well, you just told me what not to do. What do I do? I don't know what Congress will do in the future. I don't know when you're going to die. I don't know how big your estate's going to be. We can't make decisions today based on the laws for an event that might happen 20 years down the road.
Yeah.
Right? Like we could get a new Congress, new president, and they say, okay, we're going to change these rules. It's not 14 million, now it's 5. Did you know a couple of years ago they tried to lower it to 3 million? There was a few bills that went into Congress and they said, we don't like 14 million, we like 3 million. It didn't pass, but the point is
Good thing.
It's on the radar. So if you set up your trust today and you go, well, I'm under 15 million or 14. I keep saying 15 because next year it's going up to 15 million. That's why I keep saying that.
Mm-hmm.
But if you say, well, I don't have 14, I don't have 15 million, I don't have to worry about it. My question to those people is, when are you going to die? And who's going to be in Congress? And what's the size of your estate? And they go, well, obviously I don't know that. And I say, well, here's what you should do. There's a thing called a capital gains election. Capital gains election allows you to defer the decision until your spouse dies. So instead of saying today, I think I'm going to die in 20 years because I'm this old and I think Congress is going to do this, we simply say, stop thinking. Just wait.
Mm.
And when it happens and your spouse dies, then we look at the estate, we look at the laws, and we say, perfect. It's just a numbers game. Capital gains election, write that one down. That's not new, by the way. That came out 30 years ago.
So if I have an AB trust, I should be checking in with you, or
you need to check in.
you
Yeah.
need to check in.
Yeah. And if you're not sure, look in your trust and see if you see the word decedent's trust. Sometimes they call it a credit shelter trust. Sometimes it's called a disclaimer, a bypass, an exemption. Attorneys over the years love words. And so instead of just calling it a decedent's trust, attorneys have come up with like 50 versions of it. So you might see something in there like along those lines, but the point is it's worth checking out. Because once your spouse dies, it becomes very hard to fix.
Okay. All right. And then why don't you just give us, we're kind of running towards the back end here.
Yeah.
When someone dies, we said step up in basis.
Mm-hmm.
That's probably something that people don't understand. What happens when someone dies? What happens to property taxes? What happens to your basis and as far as your property taxes versus everything else that you're paying on a home when someone dies?
I'll go through 3 things on this just real quick because we're out of time. Number 1, property taxes is always a big one. People in California have Prop 13, which keeps their taxes low, and it's wonderful, but usually it goes away when you die, and here's why. And this is new, relatively new. They passed this in 2020. I say they, it's we. Everyone in California voted for this. I think they regret it now, but here's what it did. Prop 19 said if you have a home, a residence, and you live there, that's what residence means. I say that because people think, well, I have 5 residences. Like, no, you don't. You have 1 with the county. If you live in your home and it's your residence and you die and your child inherits your home and moves in, this is the part that they changed. Your child has to move into that home and make it his or her residence within 1 year of your death. Then they can get some of the same tax benefits that you got. The reason why I say some of it is there's a limit. And the limit is they take $1 million, they being the assessor, they take $1 million and they add your current assessed value. That's the most that you're going to be exempt from reassessment. So if you had a $2 million home, there could be some reassessment that happens, even if your child moves in and makes it his or her home. Now, what happens if they don't move in? If they don't move in, all the taxes go up.
To the current value.
Current value, whatever it is.
Paying
So
property tax on the current value of the home.
Yeah.
As of the day they died.
Yep.
Okay. And then what about capital gains? What about that side of things? What if they die and then you sell it the next day? What happens then?
Yeah, the rule on this, we kind of touched on this a minute ago, but I'll tell you the actual rule. Whatever you own when you die gets a new step up in basis. Whatever you own when you die gets a new step up in basis. The reason why that's important is you don't own your decedent's trust. Remember earlier I said the decedent's trust has this problem? Well, that's why it has a problem. It doesn't get a step up in basis because legally you do not own it.
Mm-hmm.
But if you own your home and it's just yours, you didn't have an AB trust, none of that, the day you die, you get a new cost basis, which means if your kids jump in and sell it the next day, they're not going to pay any tax, no capital gains tax, because the basis and the sell price are usually going to match.
Okay.
Yeah.
So let's kind of wrap this up here. If someone doesn't have a trust yet, where should they start?
So I'll tell you 2 things about this. And I'm going to put something up here in a minute. You're going to see it pop up on the screen. Just give me a second to get it up. But here's what I want to share with you. If you want to know more about what we do, how we do it, why we've kind of dominated the state of California, there's something we created many years ago called a life plan. It was designed to solve all the common issues in estate planning. We don't have time to go over that today, but if you want, when you sign up for an appointment with one of our attorneys, I'll send you a link and you can watch a webinar where we go into all 5 problems that we figured out solutions to that most estate plans miss. So you'll get that when you sign up for an appointment. Here's the requirement if you want to sign up for an appointment to chat with us. Number 1, you have to be a California resident. So if you joined us from another state, happy to have you here today. Do not sign up. We're not licensed. We can't help you. There's no way we can get around that. It's the law. Number 2, if you have a trust, you're welcome to sign up. We can review it. We can tell you what we do that will help make it better. If you don't have a trust yet and you've been thinking about getting one, most people that don't own a home, you don't have a residence, you don't have a rental property, you don't own any real property, probably don't need a trust. So don't sign up for the appointment. It's not that I don't want to help you. I just don't want to give you something that you don't need. Mm-hmm. So if you don't own real estate, just don't sign up. There might be a rare exception where you might need one, and you're welcome to call our office and check on that. But again, if you don't have real estate, don't sign up. So if you have a trust, if you own real estate, this will be a good appointment for you to chat about what it is you need to do, how it works. I'm going to share with you, because a lot of people are sensitive to this. I'm going to share with you what our fee is. I usually don't do this, but I'm going to just tell you what our fee is, because if you say, oh, that's out of my budget, that's okay. I respect that, but at least you'll know before you sign up for the appointment. If you're a single person, not married, you're single, our fee is $3,850, $3,850 to set up an estate plan, a life plan. If you're married, the fee is $4,850, $4,850. Now, when you sign up for the appointment, you will get a link to watch this webinar. It's a replay of one we did recently where we go into the 5 main problems that people need to know before they set up their trust. During that time, you'll see what it is we do and why it's so important to address these 5 problems. It's taxes, incapacity, keeping assets in the family. We didn't even cover this today, which is fine. But one of the number one things that people hate about estate planning that we've solved is they don't want to leave assets to a child, and then those assets end up with an in-law. And this happens all the time. You'd be shocked at how much it happens. Like, you leave assets to your son, a year later his wife divorces him and she gets half of his inheritance. Or we leave it to the son, he's happily married, but he dies, and his inheritance goes to his wife, and then she gets remarried because she's a wonderful person. And the grandkids are sitting there going, why did we get disinherited? Mm-hmm. You didn't. The trust just wasn't created the right way. So I won't go into it today, but if you're interested, I'm going to pop this up on the screen. There's a link at the bottom. Just click on it. It takes you to our calendar. It's a 30-minute appointment with one of our attorneys. We'll talk about your situation, what needs to be done, give you some recommendations. If you're married, by the way, make sure your spouse can attend. California is a community property state, which means if you're married, we need both of you on the phone. So don't be one of those people that say, oh, I forgot. Don't forget. Make sure your spouse can do it. And pick the best time that you can, then you can make it, meaning if you think this will work, great. If the conflict comes up, call us. We'll reschedule. We're happy to do that. But click the link now. It'll take you to a calendar. For those that want to stick around for just a few more minutes as we wrap up, when I close the webinar, it'll automatically redirect you to the calendar. So don't worry that if I close it, you didn't click it. The page will open up a new page where you can see our calendar.
Okay, and this is your studio we're in today. So for those, if you have some real estate issues and you want to sell a property or buy a property, I am probate certified, and I'd love to help you out. So my phone number is 858-449-1277. And if you call me, you have to leave a voicemail. I get about 1,000 spam calls a day. So just leave me a voicemail. I will get back to you. And then my email is Chris, CHRIS, @sdishome.com, like San Diego is home. So if you need any help with real estate, or honestly, if you just need a plumber referral, I want to just be your resource for anything real estate, anything property property related in San Diego. So I'd love to hear from you.
Yeah, that's great. Well, this was good. Hopefully you guys liked it. Hopefully you learned something today. The final thing I'll add is we've kind of just touched the surface today on estate planning. As you probably imagine, we skimmed it. There's a lot. When you get the video, when you sign up for the webinar, take some time to watch it. The webinar is stuff you've never heard before. Every time somebody watches the webinar, we're going to email to you. The first thing I hear is, I've watched 20 webinars online about estate planning. None of what you guys covered was in there. All these other estate planners aren't talking about it. So watch it before you do anything. Whether you hire us or not, that's your decision, but you'll learn a lot. And other than that, I thank you for joining us today. Thanks, Chris, for being part of this. This was fun. And we'll end now. I'm going to click some buttons. It's going to turn off. But if you missed the link, just click the button, and we'll talk to you real soon.
Okay. Great to see you guys.